So let's look at the nature of expert evidence. The expert witness should put before the court facts that require specialist skill to ascertain them, or to interpret facts that are not readily susceptible to interpretation by a judge, owing to the judge's absence of such specialist skill. Any expert opinion which is expressed on an issue which the court can decide without receiving expert opinion is in principle inadmissible because of its irrelevance. So if we have a look at that particular paragraph, you'll see now we're elaborating on what happened in the previous modules. So the expert witness should put before the court facts that require specialist skill to ascertain them, or to interpret facts that are not readily susceptible to interpretation by a judge, owing to the judge's absence of such specialist skill. Now, remember we looked at that in the previous topics, that it was by virtue of the expert's special skill, training, or experience that the expert witness then acts as a guide for the court. This topic now fleshes that out more fully. And in fact, you'll see that the authorities referred to go so far as to say that any expert opinion which is expressed on an issue which the court can decide without receiving expert opinion is in principle inadmissible because of its irrelevance, the irrelevance of the expert opinion, not of the evidence. So, in other words, where the court can decide on an issue without needing expert opinion, what's the need for the expert? And therefore, the courts will not allow if you like, a conflict of opinions, the judge's opinion as opposed to the expert's opinion. It's only where the judge is unable to form an opinion on an issue which, without receiving expert evidence, that the expert evidence becomes admissible because it becomes relevant. As a result, there are therefore two requirements for evidence to be classified as expert and for the rules governing expert evidence to operate. Firstly, the evidence must be in the nature of an opinion, and the evidence must be given by a person who is an expert. The mere fact that an expert witness testifies does not on its own mean that the evidence is expert in nature. An opinion must be expressed for it to qualify as such. In AM and Another versus MEC for Health Western Cape, a 2021 decision of the Supreme Court of Appeal, the court drew a distinction between evidence of a factual nature, given by an expert witness, and evidence in the nature of an opinion. So this is now an important distinction, and this passage is very important generally in dealing with expert evidence. And the court said the following: the functions of an expert witness are threefold. First, where they have themselves observed relevant facts, that evidence will be evidence of fact and admissible as such. First category. Second, they provide the court with abstract or general knowledge concerning their discipline that is necessary to enable the court to understand the issues arising in the litigation. This includes evidence of the current state of knowledge and generally accepted practice in the field in question. Although such evidence can only be given by an expert qualified in the relevant field, it remains at the end of the day essentially evidence of fact on which the court will have to make factual findings. It is necessary to enable the court to assess the validity of opinions that they express. Third, they give evidence concerning their own inferences and opinions on the issues in the case and the ground drawing those inferences and expressing those conclusions. Ultimately, the test for whether the court will allow expert evidence is a relative one, depending on the particular subject and the particular witness with reference to that subject. Let's just have a look at that quotation from AM. So there are three categories of functions of an expert. Firstly, it's the adducing of fact, or the introducing of facts into evidence. That is the type of situation where the expert, for instance, conducts an assessment. Let's say an occupational therapist observes the plaintiff who's able to perform certain functions and not able to perform other functions. Classic example of the first case. And the expert there is going to testify about having seen those facts. And that it will be evidence of fact and admissible as such. and it will be dealt with as a factual issue. There may be cross-examination on that. There may be cross-examination as to the witness's bias. There may be cross-examination as to the witness's ability to properly observe, whether the witness was distracted. All of those types of challenges may come to the factual conclusions being the actual performance of the plaintiff in that example. Next, second, they provide the court with abstract or general knowledge concerning their discipline that's necessary to enable the court to understand the issues arising in the litigation. This includes evidence of the current state of knowledge and generally accepted practice in the field in question. A classic example of that is in medical malpractice cases, where there might be a question about whether certain conduct on the part of a practitioner was up to a reasonable standard or not. Well, that's a classic example of the second scenario, or the second function of the expert witness. The expert must give evidence to the court as to what the general state of knowledge and generally accepted practice in the field in question. The court went on to say, although such evidence can only be given by an expert qualified in the relevant field, it remains at the end of the day essentially evidence of fact on which the court will have to make factual findings. In other words, there may be two witnesses, two experts on opposite sides who disagree about whether certain conduct is reasonable or not, whether it complies with the standard of the reasonable medical practitioner in certain circumstances. What will then happen is the court will then go through an evaluation exercise. After cross-examination, the court will assess which expert's reasoning process is more acceptable, which expert's lack of bias is more acceptable, all the usual criteria which the judges use to assess and to evaluate the expertise, the reasoning process and the opinions of the expert witnesses. And then if we look at the third category, evidence concerning their own inferences and opinions on the issues in the case and the grounds for drawing those inferences and expressing those conclusions. And you'll see in this course that I always look at that as that's at the heart now of the expert making an argument. In other words, an opinion, which is the equivalent of a conclusion, backed up by premises, which are facts, and principles which are relevant to the application of those facts and the arriving of a conclusion or an opinion at the end of that process. That then concludes the topic on the nature of expert evidence.